All right, y'all, we back with another video, man. Y'all know what we do. Always put your help with better understanding self and giving praise to the Most High. So check it. Hunter Metcalf. We got a trial attorney speaking on, shout out to Counsel Gray, just started her YouTube channel, and she explains how Hunter Metcalf can be charged with felony murder. I know people like, what? Yes, she gonna break it down to you. It's in Texas law. We gonna break it down. This is breaking, okay? Let's get it.
Okay, so there are 7 steps that I see if I were the attorney and I had to make out a case of felony murder for Hunter Metcalf.
Shout out to Trill Jackson too for sending me this, man. Appreciate you, brother.
For the death of his brother Austin Metcalf at the hands of Carmelo Anthony. These are the steps that I would take to get there. Nobody is talking about this. Okay, so the doctrine that I'm talking about is the felony murder doctrine, which in Texas comes out of the criminal homicide statute, right? It is a particular application of the criminal homicide statute, okay? And basically what the felony murder doctrine says is that if 2 or more people commit a felony and a death happens in the course of committing that felony, everybody involved can be liable for that death, regardless of whether it was intended, regardless of whether they're the one who actually did the killing. And this is what's really interesting, one of the felons or one of the perpetrators could be the one who gets killed, right? So this is the example where 2 people decide that they're going to go into a convenience store, they're going to rob the convenience store, and either one of the 2 people kills the store clerk, the other one is also liable for that murder. But here's the flip side that's more analogous to the case we're talking about here. In this case, it's more like 2 people go to rob a convenience store and the store clerk shoots and kills one of the attackers. The other attacker is liable for the death of his partner, his co-felon. Okay, so that's the analogy that I'm making here, and I believe that I can make this out, and I will tell you exactly the strategy that I would use if I had to prosecute this case. So another thing to keep in mind here is that in this case, the defendant is Hunter. Okay, so the case I'm about to make out, the defendant is Hunter. He would be being accused of being a co-felon of his slain brother. All right, so let's get into it. In order to establish the felony murder doctrine, we have to establish that Austin and Hunter committed or attempted, that's important, or attempted a felony. In this case, the felony that I'm going to make out is felony assault. And during...
So felony assault, 2 people jump on, or they both punch or hit Carmelo Anthony. Check it out.
The commission of that felony, Austin was killed. Therefore, I'm about to argue, Hunter is guilty of murder as a co-felon under the felony murder doctrine. All right, bear with me. So in order to make this out, the first thing we have to establish is that there was an assault. At this point, we don't even have to make out that it was a felony assault. All we have to do is make out that they committed an assault. And when I say they, either of them, when they were doing this act together. Now, a lot of people have said, the police statements have said, witness interviews that have come out, and there's been a witness on Carmelo's side, and there's been a witness also on Austin's side. They gave different versions of the events, but they all confirmed, including the words of Hunter himself when he was talking to the media, that they initiated the exchange and also initiated the physical contact. Okay, separate and apart from whatever Carmelo did. We'll get to that in a minute. They initiated the exchange by walking up to him, and they initiated the first contact, whether it was a shove, whether it was a push, whether it was a punch. One witness said that the 2 of them jumped Carmelo, right? We still have to wait for the evidence to come out. But what is clear is that there was some type of an assault. And that happened the minute that Austin touched, shoved, or punched Carmelo. God forbid he kicked or anything else that the one particular witness is saying, okay? All of this is confirmed. So I think everyone is in agreement about that. What people are not in agreement about is what that meant. All right, so, sorry. Okay, so a simple assault can be elevated to an aggravated assault or a felony assault if the actor, the assaulter, picked up something or used a weapon or some kind of an enhancement or something like that. Okay, so let's see what happened. If in the course of a simple assault, which is what a fist fight would be, your basic average fist fight, 2 guys fighting in a bar, some road rage or something like that, that's going to be your basic assault until one of them picks up a force multiplier. Okay, a force multiplier is a deadly weapon. Okay, now a lot of people, when they think of deadly weapons, they think of the usual things. We're going to see a list in a minute, but you know, like the guns, the cars, things like that. But Texas has said that there's a lot of things that can be deemed deadly weapons, and that a deadly weapon in Texas, it's not about what is used, it's about how it is used. It's not the what, it's the how. And what you're going to see in this list in a minute is that all kinds of things have been deemed deadly weapons in Texas, right? So my argument says that a second human is the equivalent of a weapon when the force is coordinated and overpowering. So what does that mean? If I want to hurt you, I could pick up a pipe, I could run you over with my car, I could pick up a gun, I could pick up a pipe, or I could bring my twin brother. And my twin brother becomes the force multiplier. My twin brother makes it so that I can do more harm to you than I would have done without it, right? That's what a gun does. That's what a knife does. That's what nunchucks do. They allow me to cause more harm to you, which is why I picked it up, right? They allow me to cause more harm to you than I could on my own. My brother is the thing that I showed up with that would allow me to do more harm to you than I could do on my own, okay? So let's get into this because this is supported by statute and it is supported by Texas common law. Okay, so when we're talking about deadly weapons, and the reason we're talking about deadly weapons here is because we're talking about what makes an otherwise simple or mysterious.
So basically, if there's video of both of those guys putting their hands on Carmelo Anthony, that's felony assault. So basically what she's saying is they could be charged with that. You can't put your hands and beat nobody and hit them and you can't, you know, I understand they got the complexion for the protection, but definitely if you hit somebody.
Demeanor level assault, what elevates it into a felony, into felony assault. Felony assault is necessary to establish the felony murder down the road. Okay, so here are the usual suspects: guns, knives, vehicles, cars, trucks, whatever, pipes, metal bars, a baseball bat, a broken bottle, right? I'll cut you. These are sort of the things that we know and expect to be considered deadly weapons. But Texas has also found a ton of other things to be deadly weapons that don't count as the assailant or the attacker being armed, right? So a lot of people are saying that you can't pull out a knife and cut somebody if they're unarmed. Texas law has shown time and time again that is not the case. I think I have here about 8 or 9. There are many others according to Texas law. Right now, Texas law is a fairly broad law, which means that it captures a lot of behavior in their statutes. Right, that's what sort of law and order states tend to do. But let's look at some of these things that Texas has decided are deadly weapons, not based on what they are, but based on how they are used. Okay, body parts, an elbow, the elbow of the person. Right, he didn't pick anything up. He used his elbow in such a way and on such a person that Texas said that counts as a deadly weapon. Shod feet. All that means is that it's your foot with a shoe on it. So if you kick somebody, you stomp somebody, the courts in Texas have found that a shod foot specifically, a foot with a shoe on it specifically, is a deadly weapon. Also a dog. You tell your dog, go get him, sick him, right? Sick him, kudo, whatever, whatever. Concrete sidewalks, right? So you don't even have to pick anything up in Texas for it to be a deadly weapon. And the thing about it is once the court decides that these things are deadly weapons, it elevates an assault into a felony assault, and that opens up a ton of other consequences, okay? Concrete sidewalks. You get into a fight and you bang someone's head against it. How big of a jump would it be to say a bench, a tree, right? A pillow? Texas has said that a pillow is a deadly weapon. And what happens is if you use a deadly weapon against somebody, they are entitled to use self-defense against you. And if we're talking about smothering somebody, any of these things can lead to death. That's why they're called deadly weapons, which means that the self-defender can retaliate with death, can respond with death, right? So if someone appears to be smothering you with a pillow, as was the case in Dawson v. State, you absolutely can pull out a knife or a gun and shoot that person in self-defense. The court has said it's okay. A beer bottle, this is kind of obvious. You break a beer bottle, you hit somebody over the head, you slice their neck, whatever. A telephone cord, a simple telephone cord that we all have lying around the house, it's a deadly weapon. If you can use it outside to do jump rope, or you can tie something up with it, or you can use it in this fashion, which the court has said is a deadly weapon. And if someone comes after you with a deadly weapon, and this is interesting, we're going to get to this. Even if they haven't done the thing yet, if someone is chasing you with a cord, if you think they're about to take that cord and strangle you with it, you absolutely can use deadly force in response. Pens and pencils, if they're used to stab somebody, right? Kids stab each other all the time with pencils. But in the right scenario, it can be a deadly threat warranting a deadly response. Now, the bottom one is the one that maybe is most applicable here. Your hands and fists when used with overwhelming force. Now, remember that I said that the 2-on-1 elevates the threat. This is why. Because now instead of 2 fists swinging in your direction, you've now got 4 fists swinging in your direction. And this is the case of Lane v. State. I think this was a domestic violence case where the husband was beating his wife, and the court said that his fists were rightfully perceived as deadly weapons. Okay, so this idea that you have that your attacker has to be armed is just not true. It is just false, and people should let that go because it's blinding people to what's really going on in this case. Okay, so here's the argument that I alluded to earlier, but I'm going to make the argument out here. Because we just established that there are a lot of force multipliers that a person could use against their potential victim that would warrant self-defense by the victim. Okay, so the argument you heard me make is that when Austin and Hunter showed up together, and it really doesn't matter which of them was the main aggressor, right? There's question about that, right? Not every version of what happened aligned with Hunter's version. Hunter's version was that his brother alone did this crime. Doesn't matter which one of them did it. 2-on-1 force is this, right? 2-on-1, two guys beating up one guy or threatening one guy is the same thing as one guy threatening you with a knife or a gun. The statute and the common law in Texas has shown that. So the fact that there's 2-on-1, one guy with a force multiplier, his brother, elevates it. So now we've got the aggravated assault.
So if that video shows both of them putting their hands on him, hitting him, definitely this is going to stick. Definitely, I think he beat the case. That's what everybody want to see. We want to see the video. The video is going to let us know everything. Check this out. She going in.
Assault. We've got the felony assault that we need to make out felony murder. Done. Okay. That also takes it out of the realm of a simple fist fight and the presence of the twin, the involvement of the twin. Functionally, that served as legally the same thing as having a deadly weapon. Okay. So one of the other things that people are saying is that, well, this was a simple dispute between kids. This was an immature. I saw one YouTuber, he described it as this is an immature something or other. No. Witnesses say, and there was a witness who came out, V. Kaylee M. She, I'm not sure if she was a witness, but she was a representative of the witnesses, I'll say. Even she acknowledged that they approached him, and within 5 seconds, they had already laid hands on him. She said in less than 5 seconds of approaching him, they had already laid hands on him. There's another witness that says that he was there with his two daughters, and he watched the two boys jump Carmelo. He said that Carmelo was sitting down, looking at his phone, reading his phone or something, and the two boys just started in on him, right? So this was not just a mutual fight, because a mutual fight is a defense to assault. What a mutual fight requires, or what a mutual fight requires, that there's some kind of an agreement that this is where this thing is about to go, or God forbid they say, okay, let's meet outside the bar and let's fight it out in the parking lot, and then one guy ends up getting.
So y'all see why Hunter Metcalf will probably stretch the truth. He's not going to tell the whole truth because, you know, he probably put his hands on the guy with his brother, so that'll be bad for both of them.
The better of the other guy, he can't then scream that he was assaulted because he agreed to meet in the parking lot and have the fight, right? The fact that it was unexpected, right? And both witnesses say, the girl said, Austin's friend, she said that within 5 minutes, her name is V. Kaylee M. She said within 5 seconds, they had already started touching this kid or punching him or pushing him or whatever they did. The other guy said that he was not paying attention. He was reading his phone and he was jumped, right? So this was an unexpected attack based on those two statements. This was an unexpected attack on Carmelo. So there was no mutual combat. Now, also, and we're going to get to this, a surprise attack is one justification for self-defense. You can't do a blitz attack and then expect that person to have perfect clarity and be able to perfectly assess what's going on. That's what a blitz attack does, right? 5 seconds sounds like a blitz attack. Okay, so the other thing that I want to get into, now that we've established that there was a felony level assault by virtue of having the second brother there, which the witnesses have both said on both sides, I want to get into the self-defense, okay? And I want to do self-defense 202 because everybody online is doing self-defense 101, which is, this is self-defense 101. You can't hurt somebody that's not armed. That's false. You have to meet the force with force. That is also false, right? Or I won't say that these are false. I will say that there are lots of exceptions and lots of work that the common law has done to shape the contours of what these phrases mean. So we're going to get into self-defense law 201, I mean. Okay. It says that deadly force is allowed if there's a threat of serious harm. It does not say that the harm has to have happened. You just have to have a reasonable threat. And the argument that I would make is that if it's true that what the police report says, that Carmelo Anthony is 130 pounds, if he had potentially 450 pounds coming in his direction, right? Because there's also this idea that the two boys were each about 220, somewhere between 220 and 230 pounds each, right? So Carmelo is 130 pounds, and this will all come out, but that's what the police report says. And he was confronted with 450 pounds of a threat, right? So if there's the threat of serious harm, and if I weighed 130 pounds and I was confronted by 450 pounds, I would think that I'm in danger, okay? Also, there is no duty to retreat. A self-defender does not have to retreat. It might be wise. You might recommend it. You might personally at least try. I think I would try, but he's not legally required to, right? And we have seen this exact issue in Castle Doctrine, Standard Ground, right? We have seen this litigated in the courts so many times that we know that he doesn't have a duty to retreat, whether he's at home or whether he's in public, okay? The next piece of self-defense is this idea. People keep saying, well, he didn't have a right to be under the tent. That is not true. They had, the people who managed that tent, whoever they were, the team, the school, I don't know, they had no legal right to exclude him from that tent or from that bench at all. Now, it may have been customary, it may have been courteous to not be under another team's tent, but there is no legal right to exclude off of public grounds, right? And I want you to play this out to its full conclusion. Let's say, okay, let's say that such a rule did exist, that someone could just put up a tent on public property and then exclude everybody from in it, except the people that they decided to go under their tent or their hut or whatever it is. Where does that stop? What if I tripled the size of the tent? What if I built something that took up 50% of the park? Could I just say, hey, this is my tent, nobody has a right to be there? No, you can't do that. You can't do that, right? And here's another thing. I'm going to talk about the lawsuits that are about to fly back and forth. If they try to make the argument that they somehow had the right to exclude from this area, here's the thing. The right to exclude also comes with liability for things that happen in the area that you have the right to exclude people from. So if they say that whatever the square footage is, whatever the footprint of this tent is, we have the legal right to exclude people from it, then they are liable for other things, right? They're liable for what happens in that area because they are the de facto, or not de facto, but they are the constructive owners of that space. So they're going to have to tread very lightly about this. Either we control this space, right? And with control comes responsibility under the law. With control comes liability under the law.
So y'all go check out the whole case, all right, with her. But basically, he could be charged if that video is showing that both of them is hitting Carmelo Anthony. Or even if Carmelo Anthony convinces the judge that both of them hit me, both of them, if they don't actually have the video, but they say they have video. But if the video shows both of them putting their hands on him, I think he's gonna beat it. Now, we can't determine how somebody feels about deadly force. That's what they're trying to paint, this narrative that if somebody pushes you or somebody put their hands on you, if they coming at you aggressively, you can't stab them, right? And I showed proof of somebody doing this. A guy that they've been marching around, Charleston White, and no charges happened to him. So if you feel threatened, you can't act with force. I don't know what is that. Why would they even say that, right? So I want to know what y'all think about this in the comment section. If that video is dropped and it shows Hunter Metcalf putting his hands, him and his brother putting his hands on Carmelo Anthony, do you think he should get charged? And do you think he will get charged? Let me know what y'all think in the comment section. I'll catch y'all in the next video. Peace and love.
You are totally dependent on other people to take care of your needs because you don't have those roots sunk into the ground. To have a community, you must have three things to have a community in it. You must have a wholly independent economic structure that can provide goods, service, products, and things for your own people, and jobs and tax bases for your own people. You should at least control four basic things. You should be trying to control water, food, medicine, and energy to be able to survive.
Here we got Mr. Pollock. He had a cornfield. He took advantage of a free water test from us, and this is what we found in this water. We found sulfur, we found hardness, and we solved these problems with an easy fix of 2 tanks. So get your free water test today. Stay blessed. Click the link below.